focuses on civil, commercial disputes, labor and employment law, intellectual property litigation, consumer protection, and commercial criminal arbitration. Under his supervision, at present, the firm is successfully handling all kinds of cases in over 614 districts throughout the length and breadth of the country. Mr. Chadha is also looking after the labor and allied laws compliances for many clients, including of India's largest private sector life and general insurance company, ICICI Prudential Life Insurance Company, and ICICI Landlord, and many more. Mr. Chadha completed his master's from Sriram College of Commerce in 1992 and LLB at Campus Law Center in 1995. He is a member of Bar Council of Delhi, Delhi Bar Association, and Delhi High Court Bar Association. Mr. Chadha has made representative before various forms, including Supreme Court of India and various High Courts of India. Now we officially begin the sessions for today.
Thank you, Rupam, as I would like to thank all of you who have joined this session, and I also thank the organizers of this function, this webinar. And today, what exactly we are going to discuss is, let me see, the topic is, as it says, COVID-19 and payment of rent, rights and liabilities of tenants and landlord. Now, this is the topic. And first of all, I would like to thank many of the eminent personalities who are sitting here. I could see Mr. Rao is there, and then many of them are there. I cannot see because the camera is off for everybody. My own students, Yashika, Yashu, and many of them are there. I could see them in the list. So thank you very much to all of you for coming. And Kinjal is there. Lakshchuk was there from the very beginning. Then we have so many others who are here. And I would also like to thank knowledge intellect, legal intellect, basically, and their president, Priya Gupta. She's always a strength. So I want to welcome all of you. The legal intelligence, as the name of the group is. So they are always doing wonderful work. I want to congratulate the entire team, Rupam, Priya, and so I would not waste the important time, and we'll begin as we have started at sharp at 5. Now, all of us are well aware that COVID is a exceptional circumstances. It's an exceptional thing which has happened to the world, and as a matter of fact, all of us are affected by it. Not even a single nation which is left, except few which have taken precautions like New Zealand, Korea, Hong Kong. These are the few nations where a very less effect is there, but primarily it has affected the entire world, and India has also been affected. I would like to welcome Mr. Sai Kumar Chudi Garu also. He has joined us from Hyderabad. Sai Garu, namaskar. He couldn't listen to us. So he is a prominent lawyer from Hyderabad, 25 years of standing, plus standing, I must say. And so we have seen that it is an exceptional circumstances, which is exceptional situation, which has arisen, we all have seen that it has impacted upon the entire India as well. We have seen the lockdown. We have seen how the migrant labor has, as I was seeing one, somebody has shown the picture as if the roads are full of blood of these migrant labor. That was a painful situation. So what this situation has done to all of us, and I also would like to say that I think each one of us are touched by it. Each one of us are affected. Lawyer community as such has been affected very badly. If you must have seen that approximately loss to the business as far as the lawyers are concerned is approximately 20,000 crore rupees. We know the lawyers who are basically earning on day-to-day basis. So that is one part of it. It's a sad story. I know it will be part of history soon, and we all, humankind, will win over it. That's what even I pray to the God. Now, today, the topic is that we know that many of the premises are leased out, whether residential, commercial, and all kind of other premises are leased out. So many of them are there. What will happen to these people? What will happen to the landlords? What will happen to the tenants? Whether they have to pay the rent? Everything is in standstill. If you have taken a let's say marketplace in the mall, malls are closed. What will be the outcome? There are many people who have leased out their hotels, their own buildings to the other people to running. What will happen to those all things? Now, I would like to say that we will discuss this today, and we will check that as well, and we will touch based everything in today's session. I will begin with what is basically, first of all, we have to see what is the landlord and tenant relationship. Now, I think Sai Garu, you can see us, you can listen to us. Yeah, I want to welcome you. Thank you very much. You have come, and I want to, there are so many law students are there. He was my senior, and under him I have learned, and he must be having a standing of plus 30 years, 35 years rather, if I'm not wrong. So he's from Hyderabad. I worked there under him for 5 months. Thank you, Sai Kumar Chudigaru. You have come. It always gives a pleasure. So, as we said, landlord, tenant, or leasing in the more technical term, we have seen that during the last few years, there are certain disputes between these people with regard to as they are not able to use the premises. The tenant is saying that we are not able to use the premises, why we should pay the rent. And as far as the landlords are saying that we have not stop anybody from stopping using the premises. That is one thing. And second is that we have also invested so much money. For us also, it is one of the reason why we have rented out the premises, is that we want the rent. Now, in such circumstances, I first of all would like to tell you that such relationship of landlord and tenant is governed by the law, that is Indian Contract Act 1872. We all know, there is an offer, acceptance, terms. What are the terms of the lease agreement? Terms of the contract. What are those? What is the term period of the lease? Consideration. What is the consideration? Breach. If there is a breach of the rent agreement, what will be the outcome of that? And what is the relevance of frustration? Everything is there in the Contract Act. So whenever we have to check this situation, we have to go back to the rent control, the Indian Contract Act. One sec. As I said, the most important provisions which attract a landlord and tenant relationship, they are borrowed, they are taken up from the Indian Contract Act. Now, other than that, we have certain other relevant, uh, relevant laws which are also very important. It reminds me of Section 108 of Transfer of Property Act. It, one part of it says that the tenant has right to enjoy the peaceful this thing, the peaceful enjoyment of the land is one, and second, which is important within this clause, is that tenant has to basically has to pay the charges to the landlord for the use of that premises which he has taken. These are covered under Section 108. Then very important section of Contract Act is Section 56, which is attracted. We are discussing these this topic. So Section 56 is also important, which says what is the doctrine of frustration in case there is a breach of contract. What will be the outcome of that? So that is the other aspect as far as the law, the important legal provisions are concerned. Then every state has its own rent control act. Like I would give an example of Delhi Rent Control Act, which is there. But if I may say, in a broad sense, the objective of these rent control acts was to protect the interests of the tenants. Why? These laws were they came into effect after independence, let's say 50s, 60s, and 70s. During that time, we had seen that the position of the tenants were not very strong. And that is the reason for protecting the interest of the tenants. Each state, as being a state subject, each state have passed a law. Primarily, all of the states have passed the law which talks about the rent control aspect, and primarily the objective of all these acts, including Uttar Pradesh law, you take it Tamil Nadu law, all the laws have the similar objective, that is to protect the right and interest of the tenants. But one bigger thing, as I want to tell you here, that like Delhi Rent Control Act, it applies only and only to the premises where the rent is below 3,500 rupees. So you can understand the relevance of this in today's scenario is quite less. So we will just touch base that. And so now I come back to the main point, that what is when the rent is to be paid. So what is to be done in that circumstances? Now, if the rent is to be paid, rent has to be paid as per the terms and conditions of the agreement. Now, what consists of an agreement? What conditions you will be writing? Whatever is the agreement, that this is the premises, detail of the premises, what will be the rent, what will be the term, when the rent has to be paid, what electricity and other things are to be separately paid, and so on and so forth. Whatever terms which are reasonably foreseeable, please understand, which are reasonably foreseeable by the, if I may say, by the both the parties, only and only those terms are taken in the written agreement. This is very a general thing I'm saying. If I anticipate something, then only I will be writing it. If I presume, if I foresee something, then only I will make that part of my agreement. This is a well-known fact. It's a human. If I'm thinking it will happen, so I will protect myself from this thing. So if, and while making this kind of agreement, they say that what kind of terms and conditions are to be added. That is very important. So at the time of making the agreement, all the terms which both the parties could foresee, they write these terms in the agreement. And that is why this agreement is binding upon each one of us. And then comes a very important clause, the clause which is very popular and almost in all the agreements, whether this lease landlord tenant agreement or any other agreement, if I may say, the force majeure event clause. Meaning of force majeure event: the force majeure event means all those circumstances which are beyond the control of any human being, which are beyond the control of the parties. So the things which are beyond human control, and because of those extraordinary events, if I may say so, there is a damage, there is some loss, then force majeure clause, as we call it, will be an exception for implementing the agreement. I will little bit elaborate here. Force majeure clause are such, I would say it's a kind of standard clause in almost all the agreements. What happens is that in case there is a standard form contract, there is a standard form clause, that is this particular clause. Standard form clause means all kind of clauses which are normally there exist in all the agreements. So this force majeure clause, if it is there, then what will happen if something uncertain which is beyond human control happens? Then there are two ways of checking it, whether they are beyond the human control or not. There is a test which is very, very relevant, if may I say so. The test is that first, the event is beyond the control of the person, beyond the control of human being. And second, because of this particular event, the ability of that individual is shaken up. He is unable to perform the contract. So there are two important ingredients to apply force majeure clause. One is event beyond reasonable control of the human being. And now I think we will take up, Laksh Chug is asking some question. We will take up these questions in the later half. Let me complete. Meanwhile, a lot of my friends are there. I welcome Chandrasekhar also, who represents Kotak Bank. Welcome, Chandrasekhar. Then I can see Kajol is also there, though she is today put in, she is using another phone, Mina's phone she's using. Welcome to you as well, beta. Then we were on, as I said, force majeure. There are two primary prerequisites for accepting the force majeure. One is event beyond control, and second, because of that event, it has affected the ability of the person to perform. So if these two are fulfilled, then parties are not bound to fulfill their commitment. Then they are allowed to go and see that they will not follow the law or the agreed terms and conditions of the contract. Law means that way, if I might say so. Otherwise, it is illegal if you don't fulfill the terms and conditions, what you have agreed. If you don't do, there is a breach of contract, and in case of breach of contract, section 75, 74 of the Indian Contract Act will be applicable. Those things are beyond, I know all of you are well aware of that. So now I would like to see how this COVID or Corona period, which is happening these days, whether this will fall within the force majeure or not. In a very short discussion, we can evaluate it by using the as I just mentioned, we will use the test which I had just mentioned. The test is the test of one, that things are reasonably beyond control of the human being, and second, it has affected the ability. So as far as the first thing is concerned, we will have to see whether the COVID-19 situation was beyond human control. The answer anybody could give, yes, pandemic was beyond control, no doubt about it. Then second, even if we go further, we'll see that even the lockdown was beyond control of the human being. Now comes, so it has the force majeure clause has two criteria. First criteria is this is meant and clear. What is the second criteria? Whether it has hampered, whether it has, if I may say, affected the ability of the other party. Here the tenant, whether tenant is not in a position to give the money at all, the answer is no. That is not the correct answer, because the ability is not ability. It doesn't mean that he does not have money and he cannot pay, such kind of scenario. No, it is not that easy. Ability means that it means he is absolutely disabled. What can be the situation when the tenant will be disabled? When, let's say, I can give you one example. If I have taken a storehouse on rent, let's say, and then because of fire the entire store of mine is finished, it is gone, nothing is left. So act of God will be applicable. Why? Because of the two reasons. First, things beyond human control. Very well, fire was there, it is beyond human control. What is the second thing? Ability. Now nothing is left with the tenant, what he is going to do. So that's how uh, I feel in the COVID situation, the 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 situation is such that the second condition is not fulfilled. Yes, our friend Kajal has very rightly written section 108 subclause 1 subclause E of Transfer of Petition Act. Very correct. That is the which says that not apply as the land is not destroyed. If I may say, this is what is written in that section. You can very well check it. So now I will also, write also now how to avoid landlord and tenant dispute amid COVID crisis. We'll discuss all that. Kalpana ji is asking that. Now I would like to tell you a few examples. Exactly, Komal. The permanent destruction is what is the key word. No doubt about it. It is permanently disabled. Permanently, the ability of that person is gone permanently. Very, very correct. You have rightly mentioned. So now come back to. I would like to also give you a few examples. What has happened in the previous history? If we go and see whether such situation has arisen before, the answer would be yes. We can check it way back in 1918. There was a swine flu, Swiss flu, if I'm not wrong. Swiss flu was there in which thousands of people died. But during that time also, we have seen the courts, the tribunals have not applied. Uh, okay, tribunals have not applied the 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 as you call, tribunals have not applied the principle of force majeure, and tribunals have allowed that that force majeure clause is not applicable, and in such circumstances you have to abide by the terms and conditions of the contract. So now, if I may move a little further, and as far as our current situation is concerned, if I come down to that situation, I feel there are situations where what exactly has happened. So, as I said, during the Swiss what you call pandemic which was there, what had happened, what was the viewpoint taken by the court. As I told you, the viewpoint taken by the court was very clear, and they straight away denied that it will not be applicable. Similarly, it reminds me of 2 3 other situations which has happened in India as well. If you remember, very recently swine flu was there in the territories like Pune, it was there primarily, that side. Then we have also seen situations of uh, uh, in Surat there was a plague, so there was certain cases where it was, they have tried to consider it. Then I also remember in Chandigarh, if I'm not wrong, because of malaria, such situation came, and but none of the places, though they were very localized in nature, they were not as widespread as COVID is, as far as the COVID is concerned. What I feel that these clause were not accepted by the courts. Now, let me come back to this is what is the legal scenario. If all of you just want to see 4 5 provisions which are very, very relevant, I wanted to just repeat it for the sake of convenience. Please, um, uh, one is Indian Contract Act. We have to see the Indian Contract Act. Second is where in Indian Contract Act, we have to see the agreement as such in the light of Indian Contract Act. We have to specifically see 74, Section 74, Section 56 of Indian Contract Act for station. Then, as far as the Transfer of Petition Act, Transfer of Property Act is concerned, we will be seeing certain provisions, primarily Section 108 and there its subclauses. Then we have also discussed today that there are local rent control acts are also there, including the as what you call Delhi rent control as far as the Delhi is concerned, and then for states they have separate rent control acts. And now, as far as the force majeure clause is concerned, I have very well said that what is force majeure and how and when it will be applicable, and we have seen that force majeure clause is not applicable as far as this thing is concerned. As far as my knowledge goes, as far as the precedents are going, as far as basically, so then in that case, and in that case, we will see that this force majeure clause is not applicable. Now, if I may take all of you for a minute to now, what is the current position? Because it is the COVID, and our topic is, this was the legal background, legal provisions which are relevant as far as the today's topic is concerned. But if I may take you directly to what had happened and what government has done during this COVID period, I would like to show you and I would like to mention here certain provisions. Now, first and foremost, the very initial days when the law announced, the provisions of Epidemic Diseases Act 1897 were used, and this act in itself is a very small act. I think it is a one-page act. So the government of India has done various amendments looking into the situation. And I would also like to mention here that during the swine flu period in Pune, this was used. During the Surat crisis, during the Chandigarh crisis, wherever there were pandemics, this particular act, Epidemic Diseases Act 1897's provisions were used. Now, what was the purpose? What with these act, what the government was doing? Government was passing certain directions to the local governments, to the authorities under CRPC, IPC. We know that in case they don't follow the provisions of or the advisories issued by the government are not followed by the people, masses, citizens, then in that case, what will happen is that they will be not only liable under this act, but also under the provisions of IPC. Then another act which is also relevant in today's context is National Disaster Management Act 2005, which was also the government of India has taken help of which and has taken various decisions under it. Now, I would like to discuss with you certain decisions, certain orders passed by the government. I remember in the month of April, uh, the government of India has come out with a advisory notification wherein rather two advisories were issued by the government of India, wherein one was Labor Ministry, I know, which is still existing, but it is the advisory. So it does not have the binding force of law. Now, what has happened? This advisories were of the nature that they had asked the management not to cut the salaries of the workmen. So that kind of flow was there in the beginning to protect the labor, etc. But unfortunately, on 29th of April, I think, or May, 29th of May, that advisory was withdrawn by the government. Later on, what has happened, few people have challenged that in the court of law. Initially, this was the condition of the laborer, if I may say, was challenged before the Supreme Court, and Supreme Court, unfortunately, in the beginning, had not issued the notice and asked the petitioner to withdraw the petition and disposed of the petition with with upon the statement of the Solicitor General of India that the government is taking care of it and Supreme Court's monitoring is not required. On this pretext, the Supreme Court passed an order. This was at the initial stage. Now, thereafter, what happened? Now, once all of us are some way or the other related with the law field, we are well aware that in case the Supreme Court passes a law, passes an order, the other high courts have to follow that. We are well aware. But I must say, I must salute rather the judges of Karnataka High Court and few other high courts later on. They, instead of rejecting the applications which were made once again, writs which were made once again for the conditions of the labor, the Karnataka High Court said that no, whether the Supreme Court has rejected such petitions, such writ petitions, the court, our High Court, Karnataka High Court, will certainly sees that it is nothing but, as the Karnataka High Court said, that it is the responsibility of the state government. We are welfare state, and in welfare state, the government have to do all these things. They are bound to do it. Similarly, and if you may ask me, my view on this is that yes, it was nothing but judicial activism. This is what is the real judicial activism of Karnataka High Court, and Karnataka High Court very nicely handled this case. And later on, another petition was filed in Supreme Court, and we all are well aware that Supreme Court has taken up, issued the notice to the central government, and central government filed a reply, and that was pertaining to the core issue before the Supreme Court was whether the tenant, whether the labor and what will be the fate of the labor, what will be the fate of these industrialists, whether they have to pay the full payment of the period where there was no work, and that period was in months, not in 1 month, 2 months, and then how to proceed when 1/3 of strength is allowed by the government, how they can pay the full salary. Then Supreme Court has said that, look, the industry cannot run without the labor, and labor cannot run without the industry. Labor, they cannot run their families without the industries. In such circumstances, the Supreme Court has shown a middle path, and requested these industries and laborers to come into a conclusion which is favoring both, whether you have to pay 70% of salary, 60% of salary, or so on and so forth. Now, why I gave you all this, why it was necessary. Now, as we say and we have read it, that governments have given various advisories, but unfortunate, very unfortunate, as far as the rent control things are controlled, tenant landlord things are concerned, whether the factories were open, closed, the court, the governments have given uh, no mandate to these people that how much rent is to be paid, no rules regulation made by the government. So all those advisories were issued by the government in relation to wages, etc., etc., but they were also not having any force of law. Other than that, as far as the Pandemic Act is concerned, I must say that there were certain amendments were also done by the central government in the act, and the most important was that now earlier it was this union subject. The they have allowed the union subject to become a, they have allowed the state to make laws on that. And I'm very fortunate today that two of very prominent people from Bombay have joined us, Sushila ji and Mr. Bhatia. Thank you very much. I'm honored to see you both. I'm really honored to see you both. They are pillars of of knowledge, I must say. So I'll talk about it later. Thank you very much. I'm honored that you both have come. So we were on this part, that certain whether the government has taken certain notifications, certain advisories as far as the landlord-tenant relationship is concerned. I would say the government has, few governments have given just in their press releases, they have said so. So those press releases, statements do not have the authority of law. I remember our Chief Minister of Delhi has said that we will be paying the rent of the houses, so please don't force the people to pay the rent. But at the end of the day, I don't think there is anything done by the government. Similarly, our central government has announced various announcements and crores of rupees, but were they said that we are distributing to these people during the period of Corona. But I feel I have, it's as far as the landlord tenant thing is concerned, I don't think I've seen anything. Further, now the problem remains as it is, if I may so. I would also like to mention here one judgment, rather one case came before the court. In Delhi High Court, there is a case filed wherein Justice Pratibha Singh, before Justice Pratibha Singh, this case was filed. And as an urgent hearing, this matter was heard. Justice Pratibha Singh has said that there are four kinds of agreements. One agreement is where there is a force majeure clause, and in the force majeure clause in the agreement, if it is specifically mentioned that in cases of pandemic they will be not paying the rent or something like that, so that is one kind of agreement. Other is where force majeure clause is there, pandemic mentioning is not there, so there we cannot do anything, the parties have to abide by the agreement. Then there is a third situation where the High Court says that there are cases where there are no agreements. If there are no agreements, then also the parties have to decide on their own. Fourth type of agreement which the court said is the agreement where there is a profit sharing. What we have seen is that in various malls, there are shops are given on rent where you have to just pay the profit sharing is to be done. So if there is a profit sharing, what will happen in that case? The court was of the opinion that there also you have to decide as per the terms and condition. Then whatever is the profit, that has to be shared. Nothing other than that can be done. Then Justice Pratibha Singh has specifically mentioned that the gist of the order, if I may say, is this only, that parties have to decide their own. It is nothing that court can intervene. So now I come back to the main point, which you know what is the situation. You know what is the legal proposition I discussed. You know very well that what government has done. And now we have seen one judgment of Honorable High Court of Delhi, which has given the things in today's perspective. The judgment very clearly says that it is not a situation where force majeure clause can be applicable. Number one. Number two, only and only if in the force majeure clause it is specifically mentioned that you have to what you call pandemic, in cases of pandemic, this has to be done, then only any clause like this will survive. The end is, what is the end now? Where do the tenant go? Where the landlord will have to go? Now I will tell you the answer to that. What I feel after going through all the provisions, after going through the government's act, what judges have said, what are the previous precedents, if we see, I feel in case of landlord and tenant relationship, the agreement is the topmost thing. Both are bound by it. But in such special circumstances, the only and only thing which is there is that you go and negotiate with your tenant, negotiate with your landlord, and come up with a deal through which is beneficial to both. The situation, as I said, it is an extraordinary situation. It is not that anybody will be, tenant is happy to pay rent if things are very good. The landlord is also, will be very happy to receive the rents if the properties are given on rent, and he would love to have his full share. But a mid path is what is the requirement. As our Prime Minister says, that now we have to become Atmanirbhar. So this Atmanirbharta, as I may say, has to be checked in this way only. You have to go to the, if the tenant is there, then he has to go to the landlord and has to speak with the landlord and request the landlord, look, this is what is the scenario, what to do. So the result, which I would say, is this, that in case there is a landlord tenant relationship, because of Covit, there is a situation where we have seen that markets are closed, are at a very, very low. But what to do? Rent agreement is there. You have to pay the rent. The only solution is, please come and compromise the matter between both the parties. Now I would like all of you, anybody has any question, so please ask me. And Rupan, I would like you to check if there is any question, and I would love to reply those questions. I could see there are so many questions were there.
Am I audible still?
Yes. Yes, there is Hardik is asking one question. Please ask the question. I'm waiting.
Yes. The first question is from Kalpana Bharti ma'am. He is asking that can the tenant apply the principles of frustration of contract for non-payment of rent in the absence of force majeure clause?
Well, frustration would be, I would say no. The correct answer is, but it would be in case the tenant want to leave the premises, then breach of, and he doesn't pay, then there would be a case of breach of contract. I don't think it is a case where frustration would be applicable. Section 56 will not be applicable. But if the tenant leaves without paying the rent, then he has to face the litigation. He has to pay the. So better would be the tenant should come, initiate a talk with the landlord and get the entire thing closed amicably.
So there is a question from one student. He's asking that in this pandemic and the lockdown period, people who are in rent or in PGs and outside the outstation students, the landlord or the owner is behaving rudely with them and they're not obeying the conditions of the contract and are asking the students to leave their houses or PGs. So what suggestion should we go for them?
Look,
The
as
law.
far as as far as the PGs and all these things are concerned, in and where the tenant landlord relationship is there, I must say the courts, if you ask me, the courts will decide the matter as per the lease agreement only, as per the terms and conditions of the agreement only. But if you want some solution in your favor, in favor of the tenant, in favor of the PG holder, then you have to negotiate with the landlord. You have to speak to him. You have to say, look, this is the situation, and a middle path has to be reached. You have to close down the matter with the landlord only.
So there is a question from JP Singh. He's asking that he's a tenant for an office and landlord is forcing to pay rent continuously, whereas his works and office is closed since 22nd March 2020. So what should he do?
Look, there are two things when I just said. One is, you please, with all your respect and regard, go to the landlord, speak to the landlord, speak with him, tell him that, look, this is the situation. We don't want to leave your premises, but the situation is not under control. In such circumstances, we would like to pay your rent. If in case my business is on, then I am not saying no to the rent. Now the things are closed down. In such circumstances, you have to bear something with us, and a middle path can be taken out, wherein both the parties can agree for lesser amount than what the amount is due. It will be win-win situation for both.
Thank you, sir.
Yeah.
Our next question is from Abhishek Mishra. He's asking that you to throw some light on the regulation of MHA that was dated on 29th 2020. As dated,
I couldn't get you. Please repeat the question.
The question is from Abhishek Mishra. He's telling you that MHA guidelines on 29th March 2020 was from restraining landlord from collecting rent from students and migrant labor for 1 month.
Yes.
But the Honorable Supreme Court has refused in implementing such order of government. If such order would serve the MHA circular, redundant in or it can be implemented as it was not a quashing order.
Look, I had mentioned this very question, and I had mentioned, and rather specifically mentioned, that even the Chief Minister of Delhi has said that in case don't throw away the tenants. So that's what we have seen, but nothing in concrete came out. Even that is also an advisory. Advisory means you have, please, it is advised to you, please follow this. Now, after that, nothing is being done. What is required is, if a law is passed by, a notification is passed by the government, then it should have a backing of law. I feel it was missing. And that is the reason the only solution is that we must converse with our landlord and get the situation closed and pay other, 70%, 80%, where the deal strike between the landlord and tenant. It depends. It primarily depends upon the position of landlord as well as the tenant. If the landlord has a better position and tenant cannot leave the premises, he has to agree for a higher amount. You have to appreciate this.
Thank you, sir. Moving on to the next question. It is, in a case where there is a lease and license agreement has expired and the owner wishes to recover possession of his flat, but the license is not complying, then which is the competent authority to approach in order to recover possession of the said flat, and under which provision of law?
Yeah, if it is, if it is covered, there are two type of cases can be filed. One is rent control tribunals are there in each city. If I may give an example of Delhi. So Delhi rent control, the tribunal which are made and within the court, which are looking after the cases for Rent Control Act cases. The cases which are covered in this are rental value of 3,500 will go to this, and otherwise, in case the rent agreement has already finished, the rent agreement is over, as the question says, then you can go to the civil court. So the second would be civil court under Transfer of Property Act. You can file a case for eviction.
Thank you, sir. Our next question is from Hardik Jan. He's saying, what if I am a home buyer and the developer is not being able to complete the construction of my tower and I am not getting my possession? What remedy do I have?
Yeah, if the landlord is not able to complete, the builder is not able to complete the tower, and the only reason is this COVID, then I think you have to wait. And then, I'm sorry, and then you have to, after a period when, at least for these 4 or 5 months, you have to wait. If this is the delay, then you should wait. Otherwise, you have a lot of remedies.
Sir, thank you, sir. And
no, there are many other questions. Laksh.
Yes, sir. Laksh is asking that, sir, could you please tell me why the rent agreement of residential properties is for 11 months and not for 12 months?
Look, you know what is the reason of having a 11-month lease? I think you should know. The reason for 11-month lease is that any agreement which is less than 12 months is not compulsorily registerable document as per the Indian Registration Act. And so you save your stamp duty. That is the reason you take every 11 months. Now the question is, even Resham is asking some question. We'll take that question after this. So as far as Laksh's question is concerned, after 11 months, the lease is complete and you want to get the premises vacated, you can very well get it vacated. And similar goes to with the tenant.
And the next question is from Advocate Kailash.
Yeah, you are there. Please ask.
It's saying, respected sir, my shop is on rent and the tenant had not paid rent since March. Now his deposits is also going to rent. So what should I do? As my one of the major source of income is the shop rent against the same.
So as I said, you should immediately speak with the tenant. You should talk to him. You should request him for the payment of rent. Or if in case you feel that situation has gone beyond your control, you have all rights to file a case and court will support you. Court will support and act upon the agreement only. As I said, the law is that.
Sir, what should one do if some of the tenants are raising their fees in this pandemic period, raising the rent amount?
No, they cannot rise. You can very well request. That is all. Look, first of all, I want to tell you this landlord-tenant relationship is what? It's a relationship between the two people. And these two people can negotiate very well. That is the best way of closure of all the problems, I'm telling you. In case you have a problem, please interact with the landlord. Please interact with the tenant and get the problem resolved. There is a question by Resham. She's one of my very dear students. I would like to read her question. I think you missed it. I am a landlord in Mumbai. I have commercial property. My tenant is not wanting to pay the rent for March to July. He says no tenants in Mumbai are asking the restaurants to pay rent. There is not mention of force majeure clause. Tenant asking undue advantage of the COVID situation. I'm a senior citizen. What to do? Whether you are a senior citizen or not a senior citizen, that doesn't make any difference. As I said, even the court's judgment is in your favor. You should negotiate with the client, with the tenant first, or second, if the tenant is adamant not paying, then you have right to go and file a case to the court. You can very well get your dues. When you go to the court, you will get everything. So as a matter of fact, the entire situation is in tilted, if I may say, tilted towards landlord. It is not in favor of tenants, as a matter of fact, the legal position. Now, Yogesh Shinde wants to ask if the license, what is this question? If the licensee continues to occupy, yeah, you please.
I'll read it for you, sir.
Ah.
Yes, sir. Just a second, sir. If a licensee continues to occupy licensed property after the expiry of license agreement for a considerable period of time, does this give him tenancy rights?
No, it doesn't keep. The situation you have to see whether he is continuously paying the rent. That is important. But even if he is paying the rent, it is entirely up to the landlord to ask him. Whenever the landlord wants to evict him, can give a notice to him, and the day the landlord gives this notice of eviction to the tenant, the landlord tenant relationship will be over. And primarily we have judgments in this favor that if the tenant doesn't leave the premises, there is a clause of payment of penalty, there is a clause of payment of rent at a higher rate than what he was paying. The landlord has to prove that what is the market rate, and based upon the market rate, the tenant has to pay the rent for the remaining period when he has, if I may say, overstayed or has stayed after termination of the tenancy.
Thank you, sir. Our next question is from Anushree. She's asking, sir, is there any special provision for MSMEs in such situation and any regulation by the government or not?
Well, very favorite word of our finance minister, MSME. And finance minister is regularly doing something or the other. But if you ask some owners of MSME, they will say it is nothing but just a just a mentioning of MSME, right? No problem. But I'll come back to your question. The rule is same if you are MSME or non-MSME. If as far as the tenant-landlord relationship is concerned, nothing beyond what is there in the what is there in the agreement. That is what is the primary thing, number one. And number two is that which is more important, that you must be reading in so many newspapers, articles, that government has done this for MSME, government has that, this, so many things government has done. But I am being very, very straightforward that government has done nothing as far as the landlord, tenant, MSMEs are concerned. No specific order is being passed, except few, I would say, non-genuine advisories were issued. Advisories don't have the force of law. We have to understand this.
Thank you, sir. Our next question is from Bhavna. She is asking that what about the rents and fees for the college students at the college hostels? Because some of the colleges are asking for the fees and the rent from the students.
Yeah, as far as the school colleges are concerned, we have seen the judgments, various previous judgments of our high courts, wherein in situation like this, where there's nothing has happened except one preliminary fees, nothing they can have, and hostel fees will not be charged because nobody is staying, but a minimum amount will be charged. What is that minimum amount for? Because the hostel staff is there, because there is all that paraphernalia is there. For running that paraphernalia, you need some money. So that will be proportionately divided among the students, and that amount they have to pay, not the full amount.
Thank you, sir. We have our next question from Advocate Kalpana Bharti ma'am. She is asking, can a tenant ex, can a tenant be exempt from non-payment in amid COVID-19 pandemic?
No, nobody can be exempted, as I discussed before. There is no clause, no provision, legal provision for exemption as such. So there can be no exemption. Now there
Thank
is
you.
one question from Soumya.
From,
I will read it. Sir,
yes,
can you say why the ground of bona fide requirement or non-payment of rent is a recurring cause? Is recurring cause, and therefore landlord is not precluded from instituting a fresh proceeding? What is the meaning? I couldn't get it. Now it has gone up. What is the
sir.
question? If you could just see.
Sir, Soumya is requested to please explain her question. We're moving to the next
She
question,
can,
sir. As well.
she can open the mic and speak straight away.
So, as of now, we are moving to the next question, sir. It's from Sarthak. He's asking, sir, how the doctrine of force majeure come into play in such situation of pandemic? Does Section 37 have a sweeping application on the question of liabilities?
Well, as far as the force majeure clause is concerned, as I said, it has two prerequisites, two requirements. One, that the whatever has happened is beyond human control, number one. And number two is that because of the act or because of the happening, the person, the things are beyond the control of that particular individual. So in such circumstances, that particular in a reasonable manner, he cannot, he's unable, rather is the right word. His ability to perform is disturbed. So in case the ability to perform is disturbed, then he cannot be forced to do it. Force majeure clause will come to his rescue.
Thank you, sir. Thank you for the session. As we don't have any questions as of now. So I'd request
I would like to say a few thanks, and then we have got Priya also. I think she would like to speak something. But first of all, there are so many senior people who have come and joined us. Mr. Bhatia, Mr. and Shushma ji, Sai Kumar Chudi ji from Hyderabad. Both of them have joined from Bombay. And then I've got KVA, Mr. Rao is there. And many of them I cannot see if I'm unable to see many of them, so I'm sorry for that. And I am thankful to all my students. I could see Kajol, I could see so many of them are there. I'm thankful to all of you. Saurabh, I could see you. Then so many of them are there. I am not naming all of them. Sarthak Divan, I could see you. And that's what. Thank you very much to all of you for coming. And
sir, I'd request our founder Priya Gupta to give a vote of thanks to sir.
Yes, sir. I would like to take this opportunity to place on record our heartiest thanks to Mr. Sanjay K Chadha, sir. Thank you, sir, for sparing your time, taking your time from your busy schedule, and like I feel so fortunate for us that you are here and you are taking this session. You are taking out time for us. Thank you so much, sir. Thank you so much.
You are most welcome, Priya. And you guys are doing wonderful work. I know that. And it's a start. You guys are on takeoff stage. And don't worry, I foresee that there are a lot of good future ahead in front of you. So please work hard. That is the
Yes.
key for success, I must say. And that's all. Thank you very much to each one of you who have taken out time and have made this event a successful event. I
Thank
think
you.
Mr. Bhatia wants to say something.
Yes, she wants.
No, I just miss. I don't know. So thank you very much. We'll close our session here.
Thank you, sir. Thank you. Thanks for
Thank
joining
you very
us.
much.
Thank
Thank you everyone once again.
Thank you.